right, thank you everyone, and welcome to our presentation, New Board Member 101. I'm joined by two amazing guests. It's really a treat for us. We're joined, first of all, by Emanuela Lupu, who's a partner at Smith Buss Jacobs, a preeminent law firm that handles all things co-op and condo matters. Really one of the leaders in our industry. And then I'm also joined by my colleague, Jaime Sikorski, who's a vice president of management here at AKAM, probably one of the most knowledgeable people that I know in the field of New York City building management, and has a lot of great things to share with us today. And last but not least, myself, I am a VP of Biz Dev at AKAM, and I'm going to be the moderator for this afternoon. Oh, one thing that I wanted to share before we get started today with our presentation. This presentation is going to be for educational and informational purposes only. I want to make sure that we make it clear that this presentation is not to be considered as legal advice. Obviously, every situation needs to be handled accordingly, specifically to whatever the circumstances are. And so I just wanted to make sure we put out that disclaimer and get that out of the way. So as an overview of the topics that we're going to cover today, first we're going to have board member operations, board member duties. What are the obligations? What are the things that board members obligate themselves to when they join their building's board, working successfully as a board. And then we're going to try to wrap up today's presentation with a Q&A. Okay, so first off, we're going to cover board member operations. Emma, if you could just share with us a little bit about corporate documents for co-ops and condominiums and what we need to know.
Absolutely. So co-ops are governed by primarily your certificate of incorporation, which is, for lack of a better description, it's your birth certificate. It's what created the corporation. Any rules, any guidelines that are built into your certificate of incorporation, and that can vary greatly building by building, are the rule of law for you. And they can be amended depending on what the amendment provisions are contained within. It always requires a shareholder vote, sometimes a supermajority shareholder vote, sometimes more than that. Sometimes, depending on the type of co-op that you are, there might be some third-party approval required. Beyond that, you have your bylaws, which govern the corporate structure, and you have your proprietary lease and house rules, which govern the apartment themselves. So when you own a co-op, you own shares in the corporation, and you have the right to occupy your apartment pursuant to a proprietary lease. The bylaws govern the corporate structure, the relationship between the board and its shareholders with respect to elections, voting, corporate issues, not issues related to the occupancy of the apartment or the use of the building. Those day-to-day issues, those issues that come up much more often than others do, are governed by your proprietary lease. And I'm looping in a little bit of the next section here just because it makes sense to do that. The proprietary lease is a difficult document to amend. Almost all proprietary leases require a supermajority vote of all shareholders. So depending on the lease, it's either 2/3 or 75%. And that makes it difficult to change the rules by which you live. But there's a reason for that. And the reason for that is there's some agreed upon basics that everybody expects when they come in. And those are the ones that you should follow. Your house rules govern the use of the house, as I describe it all the time, meaning your common areas. House rules are not meant to address how you occupy your apartment or what goes on within the apartment unless it's affecting the outside. So noise, carpeting, dogs, those are issues that are addressed in house rules, and they're there because they affect your neighbors. But as to the internal use of the apartment, that's your proprietary lease. Your house rules talks about common areas, hallways, lobbies, elevators, pools, roof decks. There can be a myriad of provisions in there. And the house rules are easily amendable, almost always by vote of majority of the board. In condominiums, you have your declaration of condominium, which is your birth certificate. It's what declares to the world the condominium's been created. And attached to that are the bylaws. And the bylaws and the declaration The declaration almost never gets amended. It's very difficult to amend a declaration, and most often you do require approval from mortgage holders, which makes it virtually impossible to do. In some buildings, you can amend declaration. It varies greatly. Bylaws also can be amended, but again, varies greatly. It would depend on what the bylaws themselves say as to the manner of amendment.
Hey, Emma, I'm so sorry to interrupt you. We're having some people come in and say that your audio is a bit distorted on their end.
Oh, no.
I'm not sure, maybe you're just further away from the mic.
Let me try getting closer. I wonder, is that better?
It sounds a bit echoey. Does that, Jaime and Gil, does that sound a little echoey to you as well?
Yeah, I'm hearing a little bit of an echo.
Okay, well, let me try something. Hang on a second.
Thank you, everyone, for bearing with us. And thanks,
If you
Emma. I'm
can
sorry
mute
I
it,
interrupted
that's
you.
okay. I'm going to mute it
It's
here.
not-
I'm going to log in from my phone, see if that works better.
Sure.
While
Cool.
Emma does that, I'll kind of jump in here.
Yeah.
You know, I'll certainly leave the legal stuff to her, but you know, going on to amending the corporate documents with which Emma had touched on.
Yeah, please.
You know, things like the house rules, which are also known as residential rules and regulations. You know, those are easily changed by the board according to most governing documents, and traditionally require a certain number of days notice to the shareholders or owners, typically around 30, but again, those are specific to each building. The proprietary lease or the bylaws to change that, as Emma mentioned, is more, you know, a super majority typically. So the board has the ability to make changes to the house rules on a regular basis as needed. And, you know, a perfect example of that was during COVID, kind of when boards had to make changes, you know, based off of current conditions to make sure that everyone was safe and responsible and doing the right thing. But then, you know, for bylaws or proprietary lease changes, you know, we always recommend that you know, a board kind of keep a running list of changes they would potentially like to see. And then address those in bulk as needed, because again, if you're going out for a supermajority vote, rather than going out to your owners or shareholders, you know, once or twice a year, you know, if you bulk those up in one and make different amendments to those documents, that's usually a better way to do it.
Excellent. And Jaime,
How's my audio? Is it better? Okay, great.
much
So
better for us.
I want to piggyback on that for a quick second. And
Sure,
that is,
sure.
I have a lot of buildings amending all over the place. Life has changed, the world around us has changed, and so a lot of buildings are looking to changes they can make in their governing documents to fit the realities of the world we're living in. The educational process of your unit owners or shareholders is key here. So what I encourage are informational meetings where you sit down with your constituents or your attorneys or your property manager and have an open dialogue about the changes and why they're necessary, because they are difficult to implement. That's just the one addition I wanted to make.
Absolutely. And just so that we could make this a little bit more tangible for the audience, what are scenarios that a board would decide we want to amend the documents? Just even from what you've seen, you know, just examples of you know, situations where that's been necessary.
So the two biggest in co-ops and condos, tougher in condos, have been smoking and flip taxes. More and more buildings are looking to limit or eliminate smoking within apartments because it becomes a nuisance to the neighbors, and that is a big one. It requires a proprietary lease amendment, and it requires a supermajority vote. Again, 2/3 or 75%, depending on the building. And it's a tough one to pass without a ton of education. And the other big one is flip taxes. As boards are looking for ways to generate revenue for their buildings without having to increase maintenance or common charges, charging a percentage on a sale from the seller in various methods of collection, almost always requires an amendment, both to the proprietary lease and the bylaws. So it's a substantial change, and that's a very common one. And then there are more, maybe Jaime can add to this, but there are lots of changes. I mean, I could pick up a proprietary lease and tell you about the 40 most recent litigation matters that we've handled for our buildings and how the lease could have been better written to avoid the legal fees that were expended because of some ambiguities or provisions that really didn't work well.
Yeah, I've definitely seen that. I've seen also a lot of buildings that are where their governing documents were written very long time ago. And again, with the changes of the way that people do business, there's a lot of bylaws that say that annual meetings must be in person, or that mailings must go out via USPS mail. In a time where that's not really the best way to reach people. So I think that that there's a lot of changes going on. I've seen more changes probably in the last year, or paths to changes in the last year than I have, in the 10 years prior.
Agreed. Completely agreed.
Excellent. So just to shift gears, I wanted to bring up board actions as well as voting. If we can just touch on that, because that's a huge topic. I guess, Emma, if you want to get us started on that.
Sure. So your board is comprised of however many board members, 3, 5, 7, 9, 11, whatever it is, it's generally an odd number. And within that board, you have an executive board, which are your officers, your president, your vice president, secretary, treasurer, one or more VPs, one or more secretaries, depending on the building. Oftentimes in buildings, there's a perception that the president makes the decisions. Everybody goes knocking on the president's door when they get a letter. Why would you do this to me? But the reality is that's not how it works. It's a democracy. It's a mini democracy. Board actions are taken by board vote. And in order to be able to take an action, a board has to authorize it. That vote has to happen in the presence of a quorum. So that means that a majority of the board has to be present at a meeting in order to make a decision. And then a majority of that majority is necessary to pass it. For example, 9-member board, you need 5 people present in order to have a duly constituted meeting. Of those 5 people, there's a question before the board that needs to be voted on. 3 of the 5 need to say yes on that question in order for it to pass. So it is, it's not a difficult, stringent standard if you really think about it, because it takes 3 of 9 to pass to pass something ultimately. But if you have all 9 present, you need 5 of 9. In the real world that we're living in today, a lot gets done by email. And that's where a lot of questions are coming in from buildings. And there's a lot of law that's developing on it. There have been amendments to the BCL that have enabled boards to meet by Zoom, not requiring them to meet in person. On top of that, if you're having an in-person meeting and John Smith is in California and can't attend, they can be on speakerphone and participating in the meeting. The key is that everyone needs to be able to hear the person speaking, and whoever it is that's not there, needs to be able to hear what everyone in the room is saying. What you can't do, and a lot of boards try to do, sponsors do this a lot. So those of you who have sponsors on your board, you can't proxy vote on a board level. So if your sponsor has 3 seats and one of them shows up and says, I have 3 votes, that's not true. Unless the other 2 are on a speakerphone or on Zoom or on a video chat in some way, they cannot participate. Their vote doesn't count, because you cannot attend a board meeting or take a board vote by proxy the way that you would at a shareholder meeting. So as far as voting by email, very common. Business and co-ops used to be transacted once a month, and condos, or sometimes more than once a month, because you may only have a meeting once every quarter in some instances. And the managing agent would come to the board meeting and they'd run through the agenda, take the votes, record them, and then the next meeting they'd follow up. That's not the reality of the world we live in today. Board votes by email are fine. What I encourage, I suggest, I actually require of most of my buildings is at the next board meeting, whatever you voted on by email during the course of the month, you should ratify it and get it into your minutes, because your minutes record your votes. They record what's gone on, the decisions that you've made. They're an important record of what is appropriate and what's not. from a board approval perspective. So all of those votes should be ratified at your next meeting. Someone should keep track of whether you voted on the $50, fine to 1A, or the approval of a particular contractor or an emergency situation. It all needs to be ratified at your next meeting and incorporated into your minutes.
Excellent. Thank you. Jaime, if you could just share a little bit about board meetings, agendas, and then, most interesting in my opinion is minutes, just what to include, what not to include, et cetera. And just give us a quick rundown on all of that.
Sure. Emma actually did a great job leading into this because, as she said, so much of the business is done over email, but it is important to ratify those decisions at the board meetings. Board meetings traditionally happen once a month, but there's usually a minimum number in the governing documents which say how often to meet, but with the ability of taking votes over emails and conference calls and whatnot, we found that a lot of the meetings are smoother now because it's a recap. The agenda traditionally is the same each month with the various things, and that's outlined in your governing documents as well. But then there's the, old and new business, which, kind of goes through the nitty gritty and anything that came up. Speaking to the minutes, we always recommend, when the minutes are drafted, whether that be by the secretary of the board or by the managing agent, that those are kept relatively high level. But it's important to, say what the outcome of any decision is. But, always keep in mind that the people reading the minutes are going to be, owners and shareholders who want to have as much information as possible. And certainly transparency is important, but it's also being read by potential buyers and their banks and things like that.
Outsiders.
Yes.
Yeah.
So, we always recommend a higher level simply to make sure that we're not only, making sure that potential buyers and their professionals are getting a realistic, but not too nitty gritty version of what's going on in the building. But also, there's legal implications to that. I've seen boards who want to put specific owners who are in arrears in the minutes, being that can be, given to outside people. Are there liability with that? Is it a perception of the building that you want? The last thing I'll say, and I would like Emma to kind of chime in, but when it comes to the minutes, as Emma said, you need a majority vote. That, there's some buildings which will say by majority it passed or unanimous it passed. And that's usually the preferred way of doing it. I don't think we'd ever recommend to say, well, John voted yes and Bill voted no and Sarah voted no, because again, and I think we'll speak to it later, but I think a big part of this is to look as one governing board with one voice. The decisions can happen or the conversations can happen at the board meeting, but I think I rarely will recommend being specific on who voted which way, because ultimately it was a board decision. Emma, did I miss anything?
No, you couldn't be more right. I completely agree. Less is more is my statement when it comes to board minutes. Yes, your buyers are reading them. Yes, your shareholders are reading them. More importantly, from the lawyer's perspective, at some point, a judge might be reading them, or an adversary in a litigation matter. So my job as general counsel for my buildings is to keep you out of court, or to make sure if you end up in court, it costs you as little as possible and we win right away. And that's the goal, because we can litigate any case, but we're doing a better job for our buildings when we're guiding them properly and keeping them away from the problems. So board minutes, less is more, always subjects of discussion. If you have a capital project plan, you can say discuss capital project. If you're discussing shareholders' arrears, you can say discuss shareholder or unit owner arrears. If you're having a discussion with your attorney, it's discussion with legal counsel, period. You do not put in your minutes anything that was discussed with your attorneys. It's really less is more. And as far as votes go, I discourage listing who votes for what. If to the degree that you might want to say there were 5 in favor, 2 abstentions, or 5 in favor, 1 against, 1 abstention. If a board insists on it, I'm okay with that, but I do agree with Jamie that the right way to do it, the best practice, is to at least have the perception of uniformity moving forward for the shareholders. I think that was pretty much it on that topic.
Absolutely. And the next thing we wanted to go over was distribution of documents. How's that changed over the last couple of years, and anything you have about that?
Corporate documents?
This just says distribution of documents. I'm assuming it's referring to either corporate documents. What about election documents, meaning like as far as upcoming board elections, things like that. I think this is just really open-ended. Yeah.
Right. It's open-ended. And I think, transparency and communication is key as far as I'm concerned. It's what makes for good functioning of a building. So communicating with your shareholders and making things available to them is important. If you have a bylaw amendment, have your attorney update your bylaws to incorporate the amendment, distribute it to your shareholders. If you are amending your house rules, distribute the house rules. I know AKAM has portals available where shareholders can access documents, and to the degree that you have a shareholder or a unit owner body that has the technological wherewithal to do that, great. But if you know your people and you know that they don't, then you should distribute. You should make it your business to help people know what the rules are. Are they going to ignore it? Probably. A lot of them will. And at least you've done your part and you've communicated and distributed everything there was to distribute. Every year, there's more and more required from a government level as far as disclosures, whether it's a smoking policy or an interested director policy that you're required, disclosure that you're required to make, or window guard forms, carbon monoxide forms. There's more and more every single year. So a lot tends to cross. But getting them into shareholders' hands, it really improves transparency. And shareholders may not want to come to an annual meeting. Unit owners may not be interested in coming in out of state or spending the time chatting over what's going on with the common areas or capital projects, but that doesn't mean they don't want to know what's happening. So I encourage the transparency. I encourage the distribution of documents. As far as meetings go, your bylaws are going to control. And the bylaws, most bylaws currently require a delivery. Some require specific mailing. Most require specific mailing. Some just say delivery. And in buildings where we are able to have email correspondence for all shareholders, I still think you should mail it to make sure that you've done it correctly. But I encourage you to email it also. Upload it to the portal that you're using. Maximize the likelihood that people will attend, participate, and know what's happening.
And excellent. That actually segues really well into a question that somebody asked. Is it common to share minutes with the co-op or report these things in newsletters?
So it varies building by building. Most buildings, their minutes are in management's office. If a shareholder or a unit owner wants to review them, they have the right to do that. They can go down, review them, make copies, take notes. The law is ever expanding on that topic. There is some legislation that is being proposed currently at the state level, and there's been a lot of legislation, and there's a lot out there that's coming where they're considering passing legislation that would require you to distribute minutes on a monthly basis. You're not currently required to do that. Are there buildings that do it? Yes, there are. There are buildings that post it on the bulletin board. There are buildings who email them to all shareholders or unit owners. There are buildings who mail them and distribute them. It's really it's a custom and practice situation. I think that everybody should prepare themselves that at some point they may be legally required to distribute them. So please, if there's one thing you're going to take out of this from a lawyer's perspective, you'll save yourself a lot of money. Less is more when it comes to minutes.
Excellent.
Yeah, and I would add on that, I think that transparency is so important, and communication really can make the difference for owners and shareholders as far as, knowing where the building is heading. But I've also found that, sometimes instead of minutes, which are dry and, so a high level, sometimes a newsletter or a letter from the board, even if it's quarterly, can make a big difference because it addresses more of the, the important things to the owners and shareholders, as opposed to some of the things that are discussed in a minutes, which, how much, or which vendor they choose to do a plumbing job. Again, it's their decision to make. But the important thing really for the owners or shareholders is, what is this plumbing job going to be and how is it going to impact each of you? That wouldn't be addressed in the minutes. And that's why sometimes a newsletter or, a letter from the board to owners and shareholders are really effective because it speaks to them directly. And so I've seen that really make a difference as far as communicating and really making a difference.
Absolutely. Great wrap up there. Gianna, if you could just share the next slide. So next we're going to be talking about duties, board members' duties. Specifically here, we're going to start off with fiduciary duty and liability. It's actually a topic we got a few questions about already, and I haven't answered them yet because I know we're going to cover a lot of that here. So I guess, Emma, if you could just get us started regarding fiduciary duty and liability. And then one of the questions I saw, someone just asked if you could cover the type of insurance that a board would need to retain, just to shield themselves, but just broadly as well, if you could just give us a run.
Let me start with that one, because every building, small, big, massive, tiny, I don't care what size you are, should have what's called a directors and officers liability policy. If you haven't been sued a lot, it's an inexpensive policy to get. It is an insurance policy that pays to defend individual board members and your managing agent in the event of a lawsuit brought where you are personally named. And it's a defense policy. It's not an indemnity policy. I'm not an insurance provider, but all of my boards, the first day that I'm hired, I ask, do you have a directors and officers policy? And if not, you need to get one. As far as fiduciary duties, there are a number of fiduciary duties that directors and managers, because in the condo, your managers have to the corporation. There's a duty of care, a duty of confidentiality, a duty of loyalty, and a duty of obedience. The duty of care comes right out of the business law, and it requires that you perform your duties with due care, investigation, and faith. So with the standard that an ordinarily prudent person would take in a like position. So this does not mean that you need to be right. It does not mean that you need to be perfect. It means that you have to ask the right questions and think about the decisions that you're making so that you've put enough thought into it that you're comfortable that you're making those decisions well. So what type of things do board members do with respect to the duty of care? They attend meetings. They review documents they get. Maybe they participate on committees. They pay attention. They ask questions. They listen. They understand. It's basic stuff. It's the stuff that we tell our kids to do when they're in school. But it's stuff that some board members don't do. They don't attend. They don't necessarily look at the emails. They vote because their buddy next door told them that's the right way to vote. And that doesn't live up to the duty of care that you have. The duty of confidentiality speaks for itself. You have a duty to maintain confidentiality at the board level. So if there are confidential records, you are required to protect them. You're not going to go home and share them with your husband. You're not going to tell your mom about them or your kids, depending on the scenario. And that confidentiality rate becomes even more important when you're dealing with protected records. So you mentioned earlier shareholder arrears records. You don't post those. You don't name a shareholder who's in arrears in your minutes. There's a confidentiality element there that needs to be followed. And let's not talk about dissemination. I'm not going to assume that we have board buildings represented here that have factions, but the reality is factions are a way of life in everything we do, small and large. And so I always get the question about the rogue board member that went back and told their friends who aren't on the board about the board discussions concerning how they should handle X, Y, and Z. And that's a rough situation. You're in a tough position because you want to speak to like-minded people to help you make that decision, but you can't do it because you do have a duty of confidentiality. The duty of loyalty, it's loyalty to the corporation, and your private interests should not and cannot interfere with the interests that you have with respect to the corporation. I have a lot of boards lately asking me for conflicts of interest policies and confidentiality policies for their new board members and their existing board members to sign. So to help guide everyone in the direction that they're supposed to be going in. So examples of what not to do in that realm: don't get personally involved in individual shareholder issues or disputes. You have a management company, let them do their job. You are the decider.
Absolutely. Absolutely. I always say that. I always tell board members, make me the bad guy. You know, if you have to, you have to face your neighbors on a day-to-day basis. You have to interact with them if you made a decision that they're not a fan of. Hey, take it up with management. I'm sorry, I can't I can't help you further. And that's what we're paid to do. We're paid to tell people the truth, whether it's what they want to hear or not. Yeah.
Duty of obedience is a little off. It sounds like you're obeying somebody, but you're not. What you're doing is making sure you act within your legal authority. What you're obeying are your governing documents, your bylaws. So, they say lead by example. It's true. You have a duty as a board member to act within the guidelines of the corporate documents, the ones that you want your shareholders and your unit owners to live by. As far as liability, let me touch on liability, and then I know I've been talking for a long time, but so your actions are protected by something called the business judgment rule. And as long as you act within the business judgment rule, there's little to no concern that you'll actually have personal liability for your actions. And the business judgment rule requires that you're acting with the best interests of the corporation in mind, or the condominium, and without any kind of personal gain or personal incentives in mind. So what that means is you don't always have to make the right decision. I say this to everyone. Right is never defined unless it's done in hindsight. It's always easy 2 years down the line, or 8 years down the line, or even 2 months down the line to say, oh, they made a mistake, they shouldn't have done that. As long as you're making those decisions, having exercised all of your duties, your fiduciary duties, and with the best interests of the corporation in mind, you're protected from personal liability. And that's where your D&O policy, your directors and officers policy, comes in if they were ever to be sued. And board members get personally named all the time, unfortunately, but that's why we have those defense policies in place.
Excellent. Thank you.
One thing I will add to all of that, because I have seen it happen sometimes, with the best intentions, but, board members who are involved in chats offline, sometimes it's a Google chat or a Facebook page, and whether they're sharing information that is confidential or just really involved in those, Gil brought up a really good point, which is, any individual board member should not be sharing any information. The default should always be, have you spoken to management about it? Because again, we should be the voice of the board's decisions, the bad guy when needed, but no individual board member should be sharing anything, particularly on a chat. I've seen that go sideways quite a few times.
I'm going to add one more thing to that. I 100% agree. And as important is your opinions. When you're expressing an opinion to a body at large, or even to another individual, it's important that you're cautious that there's not the impression that that's the opinion of the board. So I can bring that on a real down to earth level. John next door asks, is it okay if I change my toilet? No problem. Next thing you know, he's got a plumber in there, no license, no insurance, changing his toilet. And he says, but Joe told me I can do it. Joe didn't mean to say that. Joe meant no problem, contact management, and they'll let you know what you need. But expressing that opinion opens the co-op or the condo up to liability. So just be cautious.
Absolutely. That's definitely a situation I've seen before. I've seen that movie before as well, where a board member we'll just make an offhand, yeah, sure, no problem. And then exactly, yeah, you have an unauthorized person working on your building's plumbing. Just to move on to the next bullet point here. This is something I get asked about all the time, Jamie, is officer positions. What is the role of all the most common positions that we see on boards, and what are the most common positions that you see on boards, whether it's a condo or a co-op? Yeah, take it away.
All right. Well, mainly you have typically the president of the board, which generally, and again, bylaws and governing documents will really delineate for that building what the rules and duties and responsibilities are. But in a general sense, the board president usually gets involved in more of the day-to-day items, but does not independently make decisions unilaterally on behalf of the board. Because as Emma mentioned, it is needed for a majority vote. Vice president is very often, typically you can have multiple vice presidents, and that's someone who can step in the event that the president is not available. The secretary of the board is responsible for communications. Very often that is involved with annual meetings. Board meetings, again, if they may not take minutes. Very often management will take minutes, but ultimately they are responsible to ensure that those minutes are accurate. And as a little disclaimer that I think that they failed to mention earlier, the minutes need to be ratified by the full board. So, whether the secretary takes them or the management takes them or whomever takes them, they are not they're not for distribution until they're ratified by the full board. So that traditionally happens at the next board meeting. But the secretary's duties usually include distribution of communication of those natures. And then the treasurer, which, like most organizations, they're focused on the financial aspect of it. Very often, the treasurer will meet with the management, whether it's quarterly or monthly, to go over the financials of the building. They are heavily involved in the budget process. They will review invoices of such, but those are usually the positions. And again, very often you can have multiples. You can also have assistant positions. So you can have an assistant secretary, you can have an assistant treasurer very often, to help share some of that load. And often some of those assistant positions can also be outside of the direct members of the board.
Thank you, Jamie. That was a great recap of all the most common positions. Those are all the, what I typically see as well. So Emma, you already covered board member duty of loyalty. One thing that I wanted to ask you, this is from the Q&A box that we have. Someone asked, is it best practice to have board of directors sign a duty of loyalty agreement? And is there such a template? Do we have such a template?
So lawyers hate the words template, but we've actually drafted, and again, they vary by building because it does need to be altered for the specific circumstances involved.
Oh, Emma, we just lost your audio.
Emma,
Emma.
I think. Oh,
we may need to text her and let her know.
yeah, let me.
But in the meantime, I guess we can come back to that. But Jamie, I was going to ask you regarding conflicts of interest and the various types of, unless we have Emma back.
Okay, I'm back. Sorry about that.
You're back. Take it away. Take it away.
I strongly suggest one document, including conflict of interest clauses, duty of loyalty clauses, and in general, fiduciary duty and responsibilities. It doesn't need to be 17 pages. It's something that, I'm sure your attorneys would happily create for you. And I do think it's a best practices. I think it's a good idea.
And just to build on that question is my own question. If you don't have an explicit duty of loyalty agreement, is it just implied? Is it just implied?
Absolutely.
Yeah, that's what I figured as well.
So okay. The only reason you sign it is to make sure everybody gets it.
Mm-hmm.
People tend to feel a little more committed to things once they put pen to paper and sign off on it. These loyalties are in place and exist and are binding regardless of whether or not someone signs it.
Absolutely. Jaime, back to you. Quick question. I wanted to ask you about the most common types of conflicts of interest that you see. And I've seen quite a few of these, and I wanted to ask you about some.
Sure. As I'm sure Emma can speak to, ACL has a conflict of interest where that has to be disclosed anytime there is a conflict of interest. I believe it was enacted in 2018. So that's for both co-ops and condos. Most common conflicts of interest that I see is brokers on the board. There's some boards that will not allow brokers to be a board member because of the innate conflict of interest. There's often when it comes to vendors, if somebody has, if they're a designer, and so they will design for the building at a discount rate, but they are getting a financial impact directly for doing something for the building. You get, oh, my brother-in-law is a plumber, he can come in and do this for less. The reality is that in most of these cases, I think, it's the betterment of the building that people have in mind. I don't think it's necessarily malicious, and very often can be a cost savings. But the important things to note on that is, one, you do have to disclose it. It is absolutely have to be disclosed. But not only that, but when the conversation is happening amongst the board and the decision is happening, that board member has to recuse themselves. And that means, going into the waiting room or the other room if you're in person, while that conversation is happening. And for, in most cases, we would recommend including that in the minutes so that, so-and-so recused themselves, the discussion happened. In the case of bids, most often we would recommend having a second or third bid to compare. And show that this is the best decision for the building, and that conflict exists, but is not necessarily a detriment. Emma, what did I miss there?
Well, I think you've got to hit the nail right on the head. What I will say is, as of a couple of years ago, in every January, every board is required to send a disclosure document to all shareholders and unit owners, where they are either required to sign, every board member is either required to sign saying there have been no transactions which would constitute a conflict of interest, or if there were, they have to disclose the transaction and the details of the transaction. So a conflict is only a problem if it's not disclosed. If it is disclosed, it's up to you and your fellow board members to follow the process. But just be aware that you are required to now not just disclose it to your boards, but to all shareholders and all unit owners in the building. And not doing that if it's determined that that didn't happen and that there was a conflicted transaction, there would be some fines associated.
Excellent. And we got a question in our Q&A box. Someone asked, is it a conflict? This is a really specific question. Is it a conflict of interest to have a former management employee on a board?
Is it of your current management company? Well, if they're a former employee of the management company, there would only be a conflict if there was some financial or beneficial interest there. If they're a former employee, I'd be more worried that they would be not trying to help the management company, but hurt them in many instances. So the answer to that is, it's not innately a conflict if they don't make it one. And if that particular individual is now pushing for a change in management because the new company they work for is better, or because they didn't treat that person right when they were working there, or because of things having nothing to do with the building and not in the best interest of the building, then yes, that would be a conflict.
Excellent. And one other question while we're still on this slide, someone asked us, what are the consequences of breach of confidentiality?
Well, you would incur personal liability if you breach any of your fiduciary duties. So your directors and officers policy protects you as long as you're operating properly. If you're not operating properly and you're breaching your fiduciary duty to the entity and its members, you are subject to a claim by the members for those breaches.
Excellent. All right. Gianna, I think we can go on to the next slide. So first off, we have discrimination and preferential treatment. This is working board dynamics and working successfully as a board. So let's cover that first one now. Discrimination and preferential treatment. What are some examples that you've seen? How can this manifest itself and how do we address it? Emma, take it away.
Oh boy, I could speak for about 2 hours on this topic. Just don't do it. Preferential treatment is the same thing as discrimination. If you're treating somebody better, it's like you're discriminating against everyone else. So the most important thing to do is to treat people as if they're all equal when making decisions, whether it's income classes, the color of someone's skin, family orientation. Don't show up to a board meeting and say, we can't approve this buyer. He has 2 little kids. They're going to make a lot of noise. Everything needs to be done in a very well-balanced and equal way. And preferential treatment is literally equal to discrimination, because by treating someone better, you're basically not treating others the same.
I wanted to throw out one example. You're mentioning an extreme example of, when a buyer, a more mild example, but such a thing that I've seen is buildings that have had, really technical example here, but they said, oh, hey, we used to, before our board knew what we were doing, we used to allow people to install HVAC units that penetrated the exterior wall. And then now we no longer allow it, but for the people who did it already, can we just grandfather them in or not? And, that's just one example that I vividly remember of seeing, and one of the board members said, hey, this is preferential treatment to people that violated our new policy.
Well, you didn't, so you're going to be a little shocked by my reaction to this, Gil. If you do it correctly, you can do it without it being improper. So, I'll give you a better version of that: washers and dryers. Years ago, everybody let people have washers and dryers in their apartments. And then they realized that it destroyed the building systems, and suds are backing up into people's apartments, and it creates a problem. There's a real legal question as to whether you can force someone to remove it unless it's actively causing damage. So the act of having to tell somebody that did it already to remove it could be problematic and open up the co-op to liability. But if new professional advice comes to a board that says, I know that you guys have been doing this, but you can't continue to do it, and you now enact a policy that says from here on in, nobody can do this, I don't think that that's problematic, as long as it's being done in a systematic fashion. So you had an architect come in, your architect said, look, all of these things are causing a problem. We caution against it. We don't think you should do it. There's more examples than that. I have wet over dry as examples.
Sure.
Somebody lets one wet over dry situation happen, and then they've nonstop trouble and problems. They said never again. Is that preferential treatment? No. What is preferential treatment is my friend next door wants an AC, wants the washer dryer. I'm letting them put them in, and then the guy down the hall does, and I don't like that guy, so he can't put it in. That's preferential. So it's not about changing your policies. Changing your policies is not problematic as long as it's being done for a good reason with the duties that you have in mind. If you're doing it because it's in the best interest of the corporation, that's okay, but you have to stick to it.
Yeah,
Sorry,
one thing that I would add to this, not only are there obviously all of the legal discrimination options, but it's also, very often we see board member preferential treatment or less than, I've seen board members treated less than, to a lower standard, in other words, than other decisions. And what I would say is whenever making a decision about what to do for any unit owner or shareholder, ask the question, if somebody else asked, would you do the same thing? And as long as the answer is always going to be yes, I think that, you can generally say that you're not, showing any preferential treatment. If it's a question of the board member wants to do it, so we're going to say yes, or we're going to inherently say no. But if Joe Smith down the hall asked for the same thing, would the answer be the same? And I think that that's always something that you want to ask. A solution very often is when we talk about questions, we just say a unit owner is requesting this, as opposed to saying Bob or Sue is requesting this or the unit, but just give them, have the board speak to it in a general term to try to avoid any personal opinions.
Yeah, that's a great measuring stick. That's a great way to a logical test of, hey, would you allow anyone to do it? Would you, so it's a great way to remove any suspicion of improper treatment there. Jaime, if you could tell us a little bit about chain of command on a board, if there is such a thing, how the chain of command works, etc.
I think it's less as far as a board goes and more, to protect the board. I think Emma touched on it briefly earlier as far as, if a board member sees somebody in the elevator and is asked a question, hey, what are we going to do about this? Or I have a problem with this, that individual board member should not speak to it because again, one, they don't make the decisions independently. And two, they don't necessarily want to be the bad guy. I've seen it happen a lot with, pets in an elevator or, local law 11 noise and things like that. A lot of times things will come up and, the board members have a difficult job because yes, they're on the board, but they're also a neighbor. And they're going to see their neighbors in the hallway, in the elevators, down the block at Whole Foods, wherever they may be. So I think a best practice is, anytime somebody is approached by a resident, a shareholder, an owner, that, the first question is, did you speak to management about it? Very similarly, when it comes to staff, the traditional chain of command within a larger staff, where there is staff members and then a resident manager or superintendent, very often staff will go to a board member directly. Oh, I asked for vacation and I'm not getting it. Again, that chain of command should be, have you spoken with the superintendent about it? If the answer is no, then that's the first step that they should go. Ultimately, by the time it gets to be a board decision, it should have gone to all of it and it should be discussed as a board as a whole, not one individual member. And I think doing that kind of creates clean lines as far as communication. It also allows for input from all of the board members and doesn't put anyone on the spot in that moment.
Excellent. Thank you for that.
There's one other thing I think I just want to add to that is that in larger buildings, we see this a lot where the chain of commands between the staff, management, and the board starts to get very blurred. And especially in large buildings with unions, it's imperative that you allow your manager to manage your staff. And, no board member should be going up to the super saying, go fix that toilet now. There's a chain of command and there's a reason for that. And I've had boards get into trouble with the union for not operating along those lines.
Absolutely. Absolutely. I've seen that as well. Okay, Jaime, can you tell us a little bit about utilizing consulting professionals? When would a board utilize? When is it considered overkill? When is it necessary? Just anything you can. Yeah,
I mean, the quick answer is use them. That's why you pay them. It's really just it's a question, you have a managing agent to guide you and to use your resources. Very often that includes reaching out to the building attorney. I can't tell you the amount of times where I've seen at buildings, boards try to save money on legal fees to turn around and end up spending a lot more because a quick decision ends up being the wrong decision. Same thing with engineers, with auditors, with, tax certiaries. Again, all of these professionals are experts in their own rights. We as property managers, usually have a really good idea of when to call someone in. And if it's not needed, we have the expertise and the history of dealing with so many of these things. Just like Emma has a portfolio of buildings that she's seen almost everything. So when somebody has a question, it's use them, reach out to them, take their advice as well. If you get advice from an attorney, from a CPA, from your managing agent, really take that to heart. There's a reason that you've hired them. And it's usually a good gut check to better safe than sorry.
Absolutely. Emma, I have a loaded one for you. Making decisions, compromising, and presenting a united front as a board.
So in making decisions, you need to keep your fiduciary duties in mind. Compromise is the reality of the world. Do not compromise your ethics, do not compromise your duties, but sometimes to get stuff done, you have to compromise. So, if you want the lobby redone, but you want the $1 million job and you need to compromise to the $400,000 job to get it done, is it better to get it done and not to your particular standards, or rather not get it done at all? So compromise is part of working with any group. As long as you're not compromising your duties, that's fine. And that's the way it should be. A compromise is the preferred method. As far as united front, I think that's imperative. It's a difficult, for many boards, it's easy. For a lot of boards, it's not. There are people who are vehemently against certain decisions and want to make sure that it's known that they were not in favor of it. But creating that united front is important because your shareholders, your unit owners need to have faith in the decisions that you're making. And it's very difficult to build that faith if you're not presenting that united front.
Absolutely. And then this next one, this is an extreme scenario. This is removal of a director or an officer. When does it happen? What scenarios would lead to that? What circumstances would lead to that? And how's that handled?
Officers are easily removed by a board vote. So in just about every bylaw I've ever seen, co-op or condo, an officer is elected by the board, they're removed by the board. That doesn't mean the person loses voting power. They're still a board member. They just may not be holding that officer's position. There are technicalities that you have to go through. You have to call a special meeting. You have to put in the meeting that notice that you're going to do that. You have to take the vote. Removal of directors varies building by building. The majority of buildings require shareholder vote to remove a director. I've seen very, very few, because the shareholders are the ones electing the director. So the boards are not empowered to remove those that have been elected by shareholders. So it's almost always, and I could literally only think of one example in the thousands of buildings I've dealt with over the years where that didn't happen. So it's almost always required to happen by shareholder vote, and almost always with or without cause.
And just to throw in my 2 cents, I haven't seen a situation where a board member has been removed. I've seen where they've been asked to resign just because of, and usually that it's resolved more amicably that way. And if for whatever the extreme reason is, whether a board member is neglecting to show up to meetings or they're in severe arrears or something like that, some extreme example. And then last but not least, I wanted to ask you what a board needs to know about working with a sponsor. What's an appropriate sponsor board dynamic? And tell us.
So this again could be its own webinar. But I will say that you really do building a good relationship and a good working relationship with a sponsor that's going to remain on the in the long term is very important for the good function of the building. If you can it always happen? No, there are some, look, there are amazing sponsors out there who, even though they're using their apartments as rentals, have the best interests of the residents in mind. And they're not just worried about the bottom line. How much can they collect in rent versus how much they're paying in maintenance? And if you have that, you do whatever you can to maintain a good relationship with them, because it's not very difficult to find, but it is difficult. So as far as other circumstances, and I know we have some condos here, and this is a tough conversation in condos, especially newly constructed condos where the independent board members are just now stepping in. I'm dealing with it right now in, I don't know, probably 5 or 6 different buildings where I either represent the condo or the individual unit owner. And it's a tough dynamic because you're there, you're seeing things getting done. You may not be so happy about certain conditions or the way things are being handled. And you kind of want to go to war, but at the same time, you recognize the value in getting things done peacefully. So I always believe in approaching things from a point of peace and trying to point out to your sponsors why it would be in their best interests to be cooperative to address issues that exist, because in the long run, it avoids lots of money on lawyers and lots of expenses and damages. And I've seen sponsors be very responsive to that. So approaching it from a peaceful perspective is definitely your first step. And if you can develop a good working relationship, that's ideal. If not, then along comes me. And a bunch of architects in a lot of trouble. And all that spells is dollars and cents and lots of it. And I'm not diminishing my value. I'm a necessary part of the equation. And I have a lot to add to the equation. But sometimes what I'm adding to the equation is creating that peaceful dynamic where, I can make very not so veiled threats towards a sponsor and get them to recognize that the board could proceed in a different way, but we're trying to do this peacefully, and figuring out what that dynamic is ideal.
Absolutely. That's a great way to handle it. All righty. I think we can move on to Q&A, and we are a little bit over time, so I'm going to just take a few questions here. I have a really quick one, Emma.
Sure.
Do board members need to live in the building they are serving on the board? Example.
That depends on your bylaws.
Yeah, so here's an example. A board member may own a property in the building, but live in a different state or live in a different country.
Yeah, Gil, that really depends. Every bylaw, is different. And it will very clearly delineate if it is allowed or not. And that's usually the decision, full stop.
Excellent. Okay. So Jaime, I want to give you a chance to clarify one of the Q&As that we have here. Someone's asking, I'm finding it difficult to square the phrase less is more and then maximal transparency. I think this relates to the taking the minutes. If you have guidelines with examples of best practices for communicating board minutes, that would help. So yeah, if you could just square those two statements you made, less is more, and then also maximal transparency.
Sure.
So yeah, you're right. It is a thin line, and maximum transparency does not require for you to disclose every word that was discussed. It's about knowing what's going on. So while you guys are making decisions at board meetings and you think that people should know that they're happening, because of course you know that I'm doing the lobby. We talked about it at the annual meeting last year. So obviously we move forward with it. Telling them that you made a decision, telling them what that decision is transparency. Maximum transparency cannot be taken to the extreme. I just received an email yesterday I was in an annual meeting and I got a chat that popped up where the shareholder had a real problem with the maintenance increase and the fact that it wasn't brought to the shareholders. So there's that extreme of transparency where it's expected that you ask everyone's opinion on the color of the walls in the hallway, or what carpet are we putting down. That's an extreme, and it would be great, but it's not realistic. And the answer is you need to be realistic about what you can effectively do and what you can't. So I think that I'm sure that AKAM has some sample minutes that kind of outline what they really should look like or do normally look like.
Absolutely.
And that would be a nice guide for you guys.
Yeah. Jamie, anything you wanted to add to that?
Yeah, I think it's communicating the intentions and the decisions without communicating the nuance. Again, board meetings have a lot of healthy debate, and that's an important function of it. But that debate is not always, pertinent to the ultimate decision. And again, I think that's kind of the rationale behind, yes, you want less is more, as far as you don't need every nuance, but the transparency is the decisions that are made, whether that be, fiscal implementation or the color of the carpet or at least the vendor of the carpet or how they, but it should say after discussion, the board has decided to, install this kind of carpet, if that's, in other words, the decision. And I'm hoping that answers the question a little bit.
Yeah, absolutely.
We definitely have some samples that we can share.
And then
Okay.
just I think that about covers it. A lot of the other questions we've covered throughout the presentation. I just wanted to thank you both. This was really informative. Yeah.
Just one thing, if we can touch really quickly, because I saw it in the Q&A, and I think it's important for Emma to opine on, and that is
Sure.
Decisions made as far as executive committee within the board, and conversely, as far as committees outside of the board and their impact. Because I think
Absolutely. Yeah, please.
So committees are an important tool that I've always encouraged boards to use. Typically, a committee is always run by a board member, and committees generally don't have decision-making power. They have suggestion-making power to the board. And yes, many boards do blindly follow decisions that a committee makes because they've done months, weeks, years. I mean, I have a building that put up a solar roof after its green committee spent 2.5 years researching, interviewing, figuring it out, and they brought it to the board and really had all of the questions answered and the board passed it. It effectively would have never happened if it had to happen at the board level. So committees are great, but they don't have decision-making powers. They do need to be formally appointed. And they are covered by your directors and officers policy. So your committee members are protected through your directors and officers policy. I do, though, strongly encourage that a board member be the head of each of those committees, not non-board members.
Absolutely. Absolutely. Well, thank you both tremendously. This was really informative for everyone, I think. If anyone has any follow-up questions, everyone's contact info is up on the screen. Please don't be shy. Feel free to reach out. Both Emma and Jamie are an incredible resource to get in contact with. And I encourage everyone, if you a lot of people are really hesitant to serve on their board. I know a lot of friends of mine who live in a building, have expertise in whatever the field is. They're an accountant, they're a lawyer, they're a real estate professional, they work in construction, whatever it is, and they'll complain and they'll say, hey, oh my gosh, my building, I wish they did this, I wish they did that. And then I said, join your board. I encourage them, and oh, I don't want that. And I said, then you don't have a right to complain. If you don't want to be part of the solution, you can't complain. So that's it. Emma, Jamie, anything else you guys wanted to add before we wrap things up?
Nothing on my end. I think we've covered it, but as Gil said, reach out if you have any other questions.
And I echo that sentiment. It was a pleasure being here, everyone, and thank you for having me.
Absolutely. Thank you so much, Emma. I really appreciate it. Thank you, everyone.
My pleasure.